Friends, the big question in GST before all the taxpayers since the very inception of GST was that input tax credit, which is a right of the taxpayers, can it be barred by a time limitation under section 16 subsection 4 of the CGST Act, which was earlier the return filing period of September of the next year, and now it is 30th November of the next year. A supplementary question was whether reclamation of input tax credit can be barred by limitation or not. The first question has been answered by the Honorable High Court of Andhra Pradesh on 18th of July 2023 in the case of THIRUMALAKONDA PLYWOODS, wherein the Honorable High Court has held that input tax credit is not a statutory right but a concession, and there can be restrictions on these concessions which are granted to the taxpayers by the GST law. It has held that input tax credit can be time barred under 16 subsection 4 in spite of the fact that the taxpayer has complied with all the conditions under section 16 subsection 2, that is, it has got the tax invoice, it has received the goods or services, it has filed its returns, and the counterparty has paid the GST to the government. Even though 16 subsection 2 starts with a notwithstanding restriction, yet the High Court has ruled that this restriction is apropos 16 subsection 1, which grants the right of input tax credit to the taxpayers, and 16 subsection 4 is a non-conflicting restriction to 16 subsection 2 and is not ultra vires the Constitution of India. The Honorable High Court has thus ruled against the taxpayers, and it is clear that taking input tax credit after 30th of November now or in the previous periods after the return filing period of September would be barred by limitation until and unless the taxpayers go to the Honorable Apex Court in the matter. However, to answer the second question, what if the taxpayers have taken the input tax credit, then reversed it as a temporary reversal as per Circular 170 of 2022 and then reclaimed it back? Can this reclamation be time barred? In this, I would draw your attention to second proviso to Rule 37 capital A, which has been notified from December 2022, which provides that there is no time barring period for reclamation of input tax credit. Similar is the case when, say, the taxpayer recipient does not pay the vendor within 180 days, it reverses the input tax credit and then reclaims it back after the time barring period of 30th November now or return filing period of 30th September in the earlier periods. Therefore, to sum up, yes, the first claim of input tax credit is barred by limitation under section 16 subsection 4, and the time barring period of 30th of November now would prevail for taking input tax credit. However, reclamation of input tax credit is not barred by limitation. We hope this video would help you optimize input tax credit claim in your organization. Please do like, share and subscribe to this channel. Stay tuned. Thank you very much.